Mr. Melton.
Judge, nothing more.
Okay. Mr. Aldana, Mr. Stars, I see you're on. I have not set this matter for a hearing today. I haven't had a chance to review anything. I've been in court all day long. It's now 5:20. I'm leaving town tonight, and so I'm swamped, and there's other business I need to take care of before I leave, and I don't see Mr. McBride in present either.
I understand that, Judge. Mr. McBride isn't available. He's doing something else right now. I understand the court's position. The email I received this morning said we weren't going to address this until July 30th. I'm going to stick my neck out for Mr. Aldana and request that the court reconsider that.
Okay.
Give us a few minutes right now.
All right. Well, I'll try to do that, but I'm going to take a 5-minute recess. I've been on the bench all day long since 8:30 this morning. I didn't have a chance to eat any lunch because I am also the protective order judge, and I was doing that all during the lunch hour. I know you all sent some emails. I haven't even had a chance to read the emails or anything that's been filed. I'm not prepared for this hearing. So, and I also want you to understand, this is the Barlow case is one of 1,000 cases on the court's caseload. And I repeatedly try to accommodate the parties in this case when on short notice when you've attempted to do so, including when I met with you last week. But there's a limit to the court's availability because the court is a finite resource. We'll be on a recess for 5 minutes.
Thank you, Judge.
Thank you.
We're on the record in the 4th District Court for the state of Utah. This is the matter of the state of Utah versus Barlow, case number 221-400-978. This matter was not set for a hearing today. Mr. Aldana filed a motion to continue. He reached out to the court clerk to see if we could set a hearing today. I told the parties it was impossible for the court to do it given the court's large, lengthy calendar, everything it had going on, and other business the court has to complete before leaving town tonight. I haven't had a chance to review anything or think about it. Mr. Aldana has tried to look through the email correspondence real quick. If we're going to discuss any of this, the leadership of your office needs to be present. Mr. Means needs to be here. And I would highly suggest that Mr. Kilpack be present. So I need to hear if you're going to take the position you took in the email. I need to have your office management present to address the substance of the motion.
Well, the position I took in the email is it's not going to change.
Okay, well, I need your bosses here to discuss this issue.
Okay, when would you like to discuss the issue?
Well, I'm leaving town tonight, and that's why I said the earliest I could handle this is the 30th of July when we're back in session. The first day that I'm back in court is the 29th of July. And I have a full day that day. I don't have any time to fit it in. So we'll have to take up the matter first thing in the morning on the 30th of July.
We're set at 1 o'clock on that day. You scheduled 4 hours for that day.
All right, let me look at the 30th then, because I'm not sure. I can't remember what is in the morning on that day. Oh, that's right. I can't do it I guess I could do it at 9 o'clock in the morning, and then I have to absolutely recess at 10 o'clock for an in-person hearing that's going to take place, and that hearing will probably last all the way up until the 1 o'clock substantive motion hearings.
Your Honor, could I ask what information you'd like to have from Mr. Means?
Well, I need to have a discussion with your bosses about resources of the Public Defender's Office. And so I need them present to be there. Ms. Flowerday needs to be here. I don't know anything about Ms. Flowerday, her experience. She's been in all the hearings.
Here, Your Honor.
I know, but I'm putting on notice of what I need to hear at that hearing. I need your bosses to tell me about resources, and I need to hear Ms. Flowerday's qualifications to proceed in the matter. And frankly, Mr. Aldana, when we met last time and you said you were going to file this, I said I needed you to support your motion with evidence. Your motion is devoid of any attachment to substantiate anything that is alleged in the motion. There's no substance there.
You're under oath right now and have me testify, Your Honor?
No, I want some sort of medical evidence. I want to know, is there counseling, bereavement counseling that you can undergo that would be helpful? I mean, there's all sorts of other considerations that need to be had, and none of that is before the court.
Your Honor, this is way beyond anything I have ever seen in my experience.
Mr. Aldana, can I step in just for a second?
Yes.
Your Honor, can I be heard?
Yeah, go ahead, Mr. Stars.
Mr. Aldana is an officer of the court. If he puts something in his motion, at least this specific motion, Your Honor, I don't think he should be required to put anything else in.
Okay, I appreciate your position, Mr. Stars, but there's a lengthy record in this case, and there needs to be more documentation, in my view, given the context in which this motion comes up and the timing of it. And
Understood, Judge, and I disagree with requesting supervisors here. I've never seen that type of request before. That's my position, Your Honor.
Oh, well, thank you, Mr. Stars. That's the ruling of the court. So I'll take the matter up, as I indicated before, on the 30th of July, and I'll hear it at 9 o'clock in the morning.
Your Honor, just to put the court on notice, whatever issues the court wanted to address on that day besides this are likely going to be unripe.
Well,
they're be adequately prepared to address.
Okay, well, I'm expecting they will be addressed. They're on for hearings. Nothing has happened to change any of that, and so you should be expected to be prepared to address them in substance.
And I'm telling you flat out, Your Honor, my
Okay.
dad's kidneys are failing, and I'm not going to spend the next week of my life working on this case.
Well, then that's why you'll need to have Ms. Flowerday. You'll need to be prepared to address that. You'll need to have the supervisors there so we can talk about them, Mr. Elmbeck, because that's a very, very serious thing that you're saying. You have a professional responsibility here, and you're telling the court you're going to fail to meet a professional responsibility in a case that has been set for trial for almost a year. So I'm not asking you, Mr. Aldana, to comment any further, because this matter is not on for hearing today. It wasn't noticed up. The court's not prepared to hear it. So I will hear it, but I need substantial input from your office. And so I will hear that, as I've indicated. We are adjourned.